Thank you, Professor Reyes, for a very kind introduction. My name is George Takeuchi, and I teach international law at various universities, including Chuo University. I'm very honored to be here to talk about a very hot topic, a very controversial topic in Japanese society. And let's see. I must start. I would like to thank the Hong Kong University and Professor Reyes for inviting me here to talk about this subject. Now, let's see. This topic, the 2015 security-related legislation or military law, or they call it the law of wars in Japanese society sometimes. It has been a very controversial buzzword, certainly in 2014 to 2015. Now, how the community of international law reacted, this is a bit difficult to explain. We were very concerned, but at the same time, somewhat excited, may I say. I remember talking to a junior colleague of mine, and he was talking about more opportunities to express this concept of rights of collective security, which we have been talking about for decades, ever since the United Nations Charter. We thought of more opportunities to be on media, more articles, perhaps more jobs, as they said. But at the end of the day, what he discovered and what I relearned was that life is never that easy. So I tell you why. This phenomena, I say phenomena, because this legislation has many dimensions to it. When you think of rights of collective security or any law related to security might be an issue of international law. When you go into academia, you find more constitutional lawyers, more politicians, more of sociologists talking about this issue. Not many international lawyers on the field. So we have to start with defining this as a phenomena rather than an issue of international law itself. If you Google this legislation, you will get pictures like this. Many students, young generations, demonstrating and confronting the Diet. Now, this represents concepts as democracy. They were talking about the concept of rule of law, the constitutionality of this kind of reinterpretation of the Constitution. So not much about international law, but more of constitutional issues and social issues. Now, if you look into the debate within the Diet, also you would find many issues of constitutionality, but not much of the content of the legislation itself. Now, that makes this issue a bit messy. So what I want to do today is first dissect the phenomena, meaning that try to define which part of this legislation I'm wanting to talk about. It is very messy from probably three reasons. Number one, as I say, it is very oversimplified on media. If you seek articles on this issue, you could see that the arguments are very simplified, probably oversimplified. So the content of the law is misrepresented, in my idea. Number two, because of this misinterpretation, let's see, there are various situations in this legislation. It's not very coherent. So you have to talk about which situation you're talking about. And because this is 10 laws, acts bundled as one law, legislation, it is very difficult to grasp which part we're talking about. Number three, it uses various terms which only belong to terminology of Japanese legal community. So there are terms that even MOFA, the Ministry of Foreign Affairs, could not translate. And I will show you later. These make these all difficult to grasp. So let's see. What I want to do first, dissect the phenomenon. Now I would want to elaborate the legal structure of this secretarial legislation, try to understand what the intent of this act really was from the understanding of the government, and then try to make some analysis later. I use material from the government, which made this research very difficult because there's not much on this issue. I could find the cabinet decision in 2015, but all of the other materials are not translated yet, especially into English. So you would have to bear with my translation, which you have at your desk. I'm sorry if you have many misspellings or grammar error, but you would have, please bear with me on that. Okay, let's see. So, as I said, this has been more of issues to do with sociology, political issues, and constitutional law. I want to focus on international law on my talks. So what are we talking about? This is the framework of the legislation for peace and security. That's the word that they gave it. I would abbreviate it as LPS. So it's 10 partially amended laws, changing words for existing laws. And I will come back to this later. And one new legislation, the International Peace Corporation Law, which is they made an up version of the 2001 law concerning anti-terrorism special measures and the 2003 Iraqi measures. These were both temporary legislations. They made it more permanent. So this is what we're going to talk about. Let's talk about the content. This is from the white papers of the Ministry of Defense. It brings a chart of what they're trying to do. This is a matrix. As you can see, they have approximately 5 clusters of situations that they describe in this legislation. This axis represents the image of situations and conditions. As the situation intensifies, the Japanese government shall use more force. So at this point, this is almost non-existence of violence. Oops. This part is, there is some violence, but it is not amounting to an armed attack. This part, under international law, is consisting of an armed attack. So in this situation, the Japanese government would use force as determined by international law. The upper axis is law concerning about the defense of Japanese nationals. The down matrix, too, are about international cooperation, about UN PKO operations, and issues which deal with security issues of Asia. Japan is not involved, but we may support some logistics or information issues. So there's two axes. If you look at it from a different side, this is more about jus in bello, meaning how the Japanese government would substantiate or legitimize its actions. This action would be more of jus ad bellum, meaning how or what is the objective of the usage of force. We would come back to this later. It's a very messy chart to explain at the beginning, just to see that there are 5 big categories. Now I'd like to talk about the historical path. Why now, this kind of issue? We would have to go back to 1990 to 1991, during the first Gulf crisis. What happened in this issue? Let's see. In these years, Japan was requested to provide some logistics during the Gulf War by the United States from the United Nations. It gave a lot of money, but at the end, for example, when the Kuwait government gave a, advertisement for thanks, the flag of Japan was not there. And Japan was largely criticized for not contributing to international cooperation at this point. So this became a big issue. up to this point, the Japanese constitution saw disputes, military disputes, in two manners, two categories. Wars in aggression and wars in self-defense, a very dichotomy. So it's either you go to the enemy or the enemy comes to you. If the enemy comes to you, even with the Constitution, Article 9, we can act in self-defense, but we cannot go to the enemy. That was the idea, the basic idea in Constitution. Now, the Gulf crisis created another category which we had to deal with, meaning that what do we do in situations like the Gulf crisis? The MOFA, the Ministry of Foreign Affairs, couldn't deal with it. We made some subsequent laws, but this created a big problematic within MOFA, which is represented in some group, which some people call the new majority within the Ministry of Foreign Affairs. Like people like Yanai Shunji, Komatsu Ichiro, the late Director General of the Cabinet Law Bureau, and others who are in international relations classical realists, to say that we need some kind of legal framework for future situations as these, or in situations that are not mentioned or wasn't there when the Japanese Constitution was established. Coming into 2008 and 2014, there are two advisory panel reports for Prime Minister Abe. So he had two terms. So in both terms, he had, private advisory panels with intellectuals, and they came up with reports to deal with what kind of situations that Japanese government might have to deal with in the future. Now, I'm trying to say this in very small sentences, and to look at the more precise, you would have to look into the material, Table 1. And this is too long to read out, so please look at these later. What these two panels thought out. The first panel, chaired by Professor Yanai, I say professor because he was my professor at Chuo University, it dealt with 4 specific situations which are which are written down in page 5, original 4 situations of the advisory panel. So it was very small, saying that there are loopholes within this framework that we have to deal with. And there are situations where we must employ or use collective security to explain what we want to do, to fill the needs. So this was this first report. The second report, because the LDP, the Liberal Democratic Party of Japan, lost its place in cabinet, the second term, he made another panel. He enlarged his problematic, saying that these 4 situations are not enough. We should have more situations to deal with. So they basically came up with the same conclusion, saying that there needs to be change within the legal framework, but not changing the Constitution itself. So taking this into account, in 2014, they made a cabinet decision, taking this report, that we are changing the interpretation of Article 9, saying that there are situations that we may invoke rights of collective self-defense, which was a big debate at this time. Also, I may add into this chart that there is also one other cabinet decision in 2015, May, that, changed the reading of law so that they can quickly deploy more force into certain situations which they call the gray situation. The gray situation, I will try to explain later, are situations where it is not amounting to an armed attack, so we can't use force, but there are situations that a police force cannot simply deal with. So it's neither war, but it's not in a very peaceful situation, and the Coast Guards or police can't deal with it. So these are the things that happened in 2015 after the cabinet decision. they made the legislation, which is the subject of our talk today. So what's new, anyway? These are the things that the Japanese government can now do. Use weapons and rescue evacuation operations for Japanese nationals overseas. It was only transport to this point. So they can go into certain situations, very limited situations, but may I add, and use weapons. I use two words intentionally. The use of weapons is not the use of force. The use of weapons is more like the rules of engagement. So it is more of an act of self-defense of the individual unit or personnel, or the use of weapons to conduct certain missions. These terminology are more efficient in the rules of engagement in PKO issues. So the Japanese government has been very, how can I say, deliberate in using terminology as use of weapons and use of force. Also, they can use force now to protect weapons and equipment of US and other forces. I say other forces, meaning this word in Chinese characters, dang. So what it intends is that in certain situations when we have bases in Japan, Japan can protect these bases and equipment in American bases. Technically, in prior interpretations, this would be invoking rights of self-defense because it is within Japanese territory, but the property itself is of foreign government. And I use this kanji because mainly it's thinking of the US forces, but we have AXA, acquisition and cross-servicing agreements with Australia now. We are trying to work out the same kind of agreement with Korea. And to employ this kind of framework, we had to use the word other for this situation. We also can do inspection of identified vessels, use of weapons in PKO missions, which we couldn't do. Use of force upon rights of collective self-defense in certain situations, which I will specify later, and cabinet decisions via telephone for approval of maritime security operations. So these are what is really new, but the question is, so what is the big deal? I will try to explain later about this issue. But the another question is, but why now? Especially from the cabinet side. This is their explanation and logic in their reports. The first thing that they say is that there is a big change in security environment. Environment changing surrounding Japan, such as the emergence of gray zone situations, military buildup of neighboring countries, destabilization of security environment, such as ISIL, cyber attacks, proliferation of technology of mass destruction. Basically what they're saying, it's becoming a much more dangerous world than it was thought of when the Constitution was established. So their, how can I say, logic is that we need a new framework. They have two catchwords, or should I say terminology to describe this. The word is seamless, meaning continuity. So they want a very fast, quick decisioning system that is rational. And another terminology, proactive contribution to peace, which is a big word in English. In Japanese, it could be translated to sekkyoku-teki heiwa shugi. If you read the Chinese characters, you might be reminded by the concept by Johann Galtung, the founder of peace studies. But this is a very different concept. And what it is saying is that Japan has a pacifism in its constitution, but it's self-centered. So it's a criticism to the prior pacifisms that was in Japanese government. It says that when you look at the Constitution and its preamble, we say that we desire to occupy an honored place in the international society, striving for the preservation of peace and banishment of tyranny and slavery, saying that the Constitution states that we want to be active in the international community, trying to derive from that. In 1991, this scholar called Ito Kenichi built this concept of sekkyoku-teki Heiwa Shugi, which means proactive contribution to peace, which says that Japan should not be in this negative, how can I say, not active contribution to peace. Prime Minister Abe took him into his brain, how can I say, think tank, and trying to make this into a big deal. Now, this is the logic of the government. I want to give you two cases that were big in the media in 2014, 2015, which made this momentum of change. Other issues or incidents that they mention are in the report, are in your packet of materials, which you can read later. The first case is the DPRK, the Democratic People's Republic of Korea's launch of the so-called satellite, which is believed to be a ballistic missile. I'm sorry, it's long, that's the official wording. The word why they use it is because they say it's a satellite. It's just basically the same technology. When you use it for military use, it's called a missile. When it passes through territorial airspace, you can shoot it down. When you say it's a missile for peaceful uses, you are called a launching state. You have immediate certain rights to shoot it into air, access to space. So because we can't determine from the outside, the Japanese government has used this kind of long terminology. And as the tension in this region with the DPRK build up, we had a launch in 2016. I believe we had short-range missiles launched from Wonsan a couple of days ago. The Japanese government was very concerned, especially in 2006 when they gave no warning to neighboring states or ICAO, the International Civil Aviation Organization. Even if you don't have diplomatic relations with neighboring states, it is custom to notify ICAO, because when you have a military exercise, or when you launch a missile and you have a civilian vessel coming in, it could mean very big danger. So this alarmed the Japanese government and the international community as a whole in these kinds of issues. Now, normally we would say in my class that this is an issue of individual rights of self-defense. If it goes through your airspace, you can shoot it down. But in reality, theoretically speaking, if you want to use this right, first you would have to go through the National Security Council, then you have to go to cabinet decision, then you would have to have authorization by the Diet. 3 steps in terms of legal theory. Now let's look at what really happened in practice. This is a timetable that I got from a newspaper, case 1, on page 2. So the DPRK launches the missile at 9:31. It passes through Japanese airspace at approximately 9:41. And the whole thing is over in a few minutes. Now, if you want to have 3 deliberations in a couple of minutes, I would say that's very difficult. Someone may be having a late lunch, and someone may be in the bathroom at the moment. So instead what they do is that they invoke Self-Defense Force Act 82.2. They give an approval beforehand if such an issue would be, if such a launch would come, and if it brings an imminent danger to Japanese nationalists, the self-defense force can shoot it down. But this, in terms of international law, it would be a state of necessity, which is circumstances precluding wrongfulness under the international, the ILC's State of Responsibility Act. So this is an exception, not a rule. So they say that we can't keep using these exceptions to explain what we're doing or what we want to do. So this is one issue. The second issue is an issue that was on TV very much last 2 years ago, red coral poaching by Chinese vessels. This is a picture of Ogasawara Island near Okinawa. These are the ships that the Coast Guard sighted, and what they are doing is that they're trying to get these specific kinds of corals, which are very, very expensive and very, very hard to, how can I say, grow. And these ships, but we found out that they are not regular fishermen. We found that they are mostly members of organized crime, employing former fishermen, using decommissioned ships to make a lot of money. If you see the material, you can find that you are charged 4 million yen, Japanese yen, if you are caught, and if you are caught on the EEZ, 10 million yen. If you are successful in these tours, if you go back and sell off these corals, they will make you more than 10 billion yen. And you will get your ship back even if you are caught. So I would say, except for the fact that it's illegal, and except for the fact that it's destroying the environment, I would say it is a very lucrative job to have. Now, why wasn't the Japanese Coast Guard able to catch all of these? Of course, we were very active in these oceans, but if you catch one vessel, you will have to take them all the way back to Yokohama for court ruling. And with the, scapegoat of one ship, the other ships can do their operation. So this was a big issue on TV, and thanks to the Chinese government, actually, they were very cooperative on this issue, and by November, we had lost all sightings. So this was a very big issue of cooperation between the Chinese and Japanese government as well. Now, what frightened the Japanese public was around October and September. These are the typhoon seasons. What happened is that there was a big typhoon, and all of these ships they came to Ogasawara Island into port. Normally, we wouldn't let them in, of course. We're kind of afraid of these people. But, as he said, this is a humanitarian procedure that they have to take. So they took in these ships. They stayed in port for a few days. Schools were closed down. Stores were closed. And the mayor of Ogasawara Island came to Tokyo. He said that we're terrified, saying that what if these, not very good people came into the island and did some more infringing activity? And part of the LDP took that more as a security issue, saying that what if these ships were terrorists or more than organized crimes? So they said that in these situations we have to look for more operations that we can do. So these are situations that gave the momentum for this kind of legislation, as I said. We would come to this later again. So all of this talk, it all leads to more of the issue of Constitution Article number 9, which is very famous within our Constitution. I won't read it out, but basically you can see that the terminology is very similar to the United Nations Charter, Article 2.4. It uses words like the use of force or threat or use of force. What it's saying in subsection 1 is that we will abandon the right as a sovereign state to go into war, the threat or use of force. And subsection 2, we would abandon all kinds of forces to this kind of activity, to enable it. So it looks very straightforward. But the question is, has the interpretation has always stayed the same? Basically, in courses of Constitution, you would think that this is very straightforward. Actually, it has changed a lot in years. And we will go through this later, but in this framework, there are two types of war that they talk about. This is more of constitutional theory. Wars in self-defense and wars of aggression. Wars in defense, as I said, is when the enemy comes to you, you have no choice, you use minimum force to draw back this force. Wars of aggression, which is prohibited by Japanese constitution and international law is the kind of war that you would find in Kellogg-Briand Pact or other international treaties which prohibit it. So the general interpretation is that, in Constitution, is that both wars, war in aggression and war in self-defense, are abandoned in the Japanese Constitution. That's what constitutional lawyers would tell you. The Japanese government says that they interpret this phrase in order to accomplish the aim of the preceding paragraph as saying that we abandon the wars of self-defense, wars of aggression, but not wars of self-defense, meaning that there are situations, certain situations, that the Japanese government may use rights of self-defense. So it doesn't mean that Japan has abandoned the right of self-defense, which is a right given to all sovereign states. However, depending on how you interpret the phrase mentioned, the constitutionality of war and self-defense is also in question. So there's no consensus in theory about this question. So we would have to focus on the Japanese government's interpretation, as I said. Has it changed? Yes, it has. If you look into the time frame of Table 1, it starts out with the 1946 statement of Prime Minister Yoshida. This is more coherent with the interpretation of constitutional lawyers, saying that all types of wars and the use of force is prohibited, period. Very easy to understand. But in 1981, by the time we experienced the Vietnam War, the Cold War, American forces and the international community has asked Japan, of course we had the Korean War as well, to change its position in these kind of situations. So Japan retains the right of self-defense, however, shall not invoke the right of collective self-defense due to constitutional restraints. That is the major interpretation taken by the Japanese government. It's still, well, it standed until 2015. Now what they're saying is, in certain situations, the right of collective self-defense with limitations exist. Not saying that it's a full spec, the regular type of collective self-defense that we would teach in international law classes, but there are situations that we can only explain by explaining with this kind of right. This part was the part that I say is very oversimplified, amplified, and taken into wrong misinterpretations in media, and they have not translated it. So we have rumors saying that they're thinking of new frameworks for drafting, or there are ghosts of the past coming back, or that Constitutional 9 is already dead. It's still a big issue, but from the perspective of international lawyer, that is an overstatement, and I tell you why. Let's see. Now we're talking about the Constitution, Article 9. This has brought various limitations in the use of self-defense forces. We had a very small budget. It was not even a ministry until recent days. And there are certain weapons that the Japanese self-defense force couldn't have, not because they can't afford it, but they just didn't have because of the Constitution. These are words that are very hard to explain in English. So I left the Chinese characters so that you can get an idea. One idea that is only found in Japanese constitutional is ittaika, with the use of force. The Minister of Foreign Affairs could not translate it into English. Ittaika means becoming one. So in military operations in foreign land, for instance, like PKO situations, there are types where you want to have logistics, transport, how can I say, make roads, and other types of situations. Now, if you come across a combat zone, and if you're transferring some, how can I say, let's say some ammunition, water, some things that might be used for combat, from the Japanese perspective, we're just carrying things. That's maybe their argument. But from the, how can I say, the participant of the conflict, they may see the Japanese self-defense force actively participating in the combat, in the use of force. So this is the concept of itaika, meaning that we cannot have a situation where the Japanese self-defense force is in the combat zone because we are in line or we are in one with the other friendlies. Another question is senshu boe, the doctrine of exclusively defense-oriented posture. Another big word meaning that we will not use force or weapons for conflicts only for self-defense. So we cannot take troops outside the territory of Japan. This was a very big issue during the Gulf War. It was a big issue during the PKO missions. It's still a big issue now. So during the Iranian-Iraqi war in the 1980s, we had a lot of foreigners in foreign land, Japanese nationals, that wanted to evacuate from Tehran. We wanted to send the self-defense force, the cabinet wanted to, because it was a very special situation, but the Diet ruled that we can't send the self-defense force out of our territory because it would be against Article 9 and Senshu Boe. So what they did is they tried to request the Japan Airlines. They declined our request. So what they did is the Turkish Airlines, in the favor that we did in the Meiji era, returned the favor, and the Turkish Airlines took all of our nationals back to Japan. This was a big deal. It made actually a movie last year, and we're trying to, how can I say, remember this kind of incidents, I suppose. Now, another issue. From the itaika with use of force, there's a distinction of combat area, non-combat area. Even though we may send troops on foreign territory, they cannot operate in combat areas. So it's hard to distinguish where the combat would actually occur, but the logic is because they're not operating in non-combat areas, that would not interfere with itaika, with the use of force. This is their rhetoric. Another point that they would give is that kaketsuke keigo, coming to the aid of geographically distant and units of personnel under attack, or use of weapons for the purpose of execution of missions. Ever since Secretary General U Tant, the mission of the PKO forces is not only patrolling, not only going in between how can I say, sides, not taking sides, but there are missions where you have to use weapons in terms of patrolling or keeping the public security safe. But the Japanese PKO was not able to participate in these kinds of new PKO issues because they said, what if we come into a situation that our friendlies are having a conflict with one of the sides, and we are not actually shot at, but can we shoot back for our friendlies? So we're doing some patrolling for our friendlies. So let's say that we come into a situation that the United States or let's say China are in a conflict in Africa where the insurgents are attacking these PKO forces. And we're trying to transport some things, and we see them shooting at the Chinese forces, Chinese PKO forces. Not helping them would be unreasonable. We just can't leave because we were not shot. But coming to this concept, using weapons in this kind of situation, there are the risk of having a dispute with Article 9. So to do this, we said we're only operating in non-combat areas. That is the logic. Now this is all changed in terms of the new legislation. So another thing is there are new conditions for the use of forces as measures of self-defense that, as we can see. The red area are areas are new terminology that is added. Basically what it's saying is that there are three conditions, meaning that we can only use force in armed attacks. There is no, and when there's no other appropriate means, and it is only limited to minimum extent. This is not new. What is new is that when an armed attack against not only us, but to foreign countries that are in close relationship, probably the United States, that what they're mentioning, occurs and threatens Japan's survival and poses a clear danger to fundamentally overturn people's right to life, liberty, and pursuit of happiness. This is our long passage. In Japanese, we only say sonritsu kiki jitai. The wonders of Chinese characters. How can it shorten things? So this is new, meaning that we are recognizing collective self-defense in certain situations. Now, when we come back to international law, as we said, this issue can be seen from the three typologies of military activity in the Nicaraguan case, ICJ 1986. The International Court of Justice ruled or made three kinds of military activity. Armed attack, the most gravest form of use of force. It's a subject of use of force. So you can use force when there's an armed attack. But in the case of Nicaragua, there was cases of infringement that does not amount to an armed attack. So there is a big infringement made by not a state, but terrorist groups or insurgents. This right, military activity, is based upon state-to-state relations. But in this case, the magnitude was very big, so they had to make another category. They ruled that it is subject to countermeasures with force. Of course, this was later denied by ILC articles on state responsibility, but that was the idea. You can't use force in situations that are not an armed attack. This was a big issue in the so-called gray zone situations in LPS. In the Nicaraguan case, the CIA were supporting Contra and insurgents in Nicaragua. They were giving them money, they were training them, and the argument there was, well, the United States forces are not directly involved, so you can't say it's an armed attack. Another category that they have is prohibited intervention, subject to countermeasures except for the use of force. So this is more of logistics, providing transport, military activity, but it's not combat. These are the three categories that are employed in international law. It is very, very persistent in the oil platform case, and this is what we teach in international law classes. And let's see, this is all related to the issue of United Nations Charter 2, subsection 4, very famous. This is the only passage that I make my students memorize, by the way. It says that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the United Nations. So there are certain limitations in these kinds of, so what the United Nations Charter says is that we do not recognize the use of force or threat to use force to solve problems of international relations. That's very straightforward. The exception would be Article 51 and Chapter 7. What Article 51 says is that there are certain cases, particularly of self-defense rights, where you can actually use force. Now, it has various conditions to use this kind of force. First, it has to be an armed attack by a state. So, and the second part would, you have to report the Security Council, and the purpose of using this kinds of force would be for the territorial integrity or political independence of any state. So it's pretty straightforward if you read the sentences. Now, the question is, it says nothing in the present charter shall impair the inherent right of individual or collective self-defense right. Certain terrorists have interpreted this passage saying that even though this passage is pretty straightforward, it doesn't mean that the natural right of states, meaning rights of customary international law, have faded away. Meaning that in certain situations where the collective security framework of the United Nations doesn't work, you can invoke this customary international right. This has been called the permissive approach, as I say. So there's two ways of approaching self-defense. This comes from the framework, a debate in the late 1950s and the early 1960s between Lord Ian Brownlee and Derek Bowett on the famous debate on the International Journal of International Law, American Journal of International Law. Basically, the restrictive approach is the approach by the ICJ, very restrictive, saying that you can only use rights of self-defense only to a state when your territory is attacked, and you have to report to the Security Council, and so on and so forth. So it's very simple. It's an exception to Charter 2, subsection 4. Now, the permissive approach, by what it said, is that, well, there are certain situations that customary international law still pervades. This interpretation is taken by particularly two states, Israel and the United States of America. Israel in Operation Entebbe. This is a hostage situation in Africa. Hostages were taken inside a plane. Israeli government sent troops to actually, rescue the passengers and do away with the terrorists. Another situation would be the Iranian hostage situation. The same logic was taken. So there are practices that support this approach as well. Also, September 11, the United Nations Security Council did not criticize the United States for bombing Afghanistan for terrorist attacks. If you take the strict approach, you cannot bomb a state for an act of a private citizen, a terrorist group. So these are the kinds of approaches. And also, may I say that the reason for invoking this right may include rescue operations for nationals overseas and preservation of economic interests. So the reason for using this right is also very wide compared to the restrictive approach. So what is the Japanese approach to the right of self-defense? I give you a somewhat old dialogue within the Diet. I have another situation that because of they give the same point I have in your material. Both are between the Ministry of Foreign Affairs and the Cabinet Legislation Bureaus. These are much in a rivalry within the Japanese government. MOFA tends to have a perspective from the international law. The Cabinet Legislation Bureau takes the position of the Constitution, so they can make the authoritative interpretation. So given the same question in the Diet, for the protection of nationals overseas, Ichiro Komatsu, who later actually became the Director General of the Cabinet Legislation Bureau, answers that there are situations where rights of self-defense may be recognized to rescue its nationals with minimum force under international law. So he's taking a general approach. He's not saying that it's the Japanese approach, but he's saying that there are situations where you can have this right. Let's look at what Masaki Omori says. Under the Constitution, the use of force may be permitted under the three conditions for self-defense set prior, whether the question qualifies that you give, can we use force to, can we send troops to foreign soil to rescue nationals, Japanese nationalists? Well, the question is whether the question qualifies the first condition, which is imminent and illegal activity of aggression, cannot be answered in the assertive way. However, in general, the mentioned situation does not qualify these situations. So these two ministries are in a tension. There's a very interesting slang within MOFA to describe the Cabinet Legislation Bureau. In Japanese, we call it marudome. It stands for marude domestic. I would hesitate to use the language, but I think the nuance would be too damn domestic. So they are in a rivalry situation. So what the Japanese approach has been is they would take first a permissive approach to rights of self-defense. So they're saying that we can, in some situation, use force under international law if we have to rescue our citizens overseas. But then take the limitations of the Constitution, saying that, well, these limitations have to be very strict. Not as strict as the ICJ, but putting more weight to limit the permissive approach of the MOFA. So the general idea here is that there's two phases in this. A permissive approach by MOFA, by international law, then set constitutional limitations. This is about individual rights of self-defense. What does Prime Minister Abe think? This is a situation that was actually taken back. This is saying that what if there's an incident in the Straits of Hormuz? More than 80% of our tankers, oil, have to go through the strait. So their argument at this point, this was later taken back, but they were saying that if we cannot have the oil from here, we would be having a grave interest in economic interest. So we could send ships of self-defense force to clear sea mines in this section. Taking mine sweeping in these areas would be considered using rights of self-defense in this perspective. So I would say that even though the situation was taking back, the same approach of a permissive approach and then constitutional limitations still stands in this situation. Now, this is the general framework. Now, I would like to go back, to this picture here. I said there are five categories. What are we able to do now? First, talk about transportation of Japanese nationals overseas in situations where there might be a risk of crisis. This is not new. What we can do now is rescue Japanese nationals and foreign nationals, friendlies, in the same situation. And at very specific situations, even use weapons. This is one point that is new. But if we look, this may be very radical change, but if we look into the conditions, Article 84, subsection 3, enabled to use weapons in these kinds of situations, evacuations, you would think of search and rescue, going into combat zone and finding out, trying to search out nationals and taking them back. But this is not the case. For this kind of operation to be, you would first have to have the order of the defense minister. You have to have the request of the Ministry of Foreign Affairs, and you would have the approval of the Prime Minister. Also, you would have to have the consent of the territorial state, and you would also have to prove that this is a non-combat zone. So this is not an operation based upon self-defense right. It looks like it, but their argument is it's not. So the only conditions that you can use weapons is that you're trying to evacuate and you run up in a situation that you're shot. Even in these situations, you have to qualify the domestic requirements under Japanese criminal law, Article 37 and 36, I believe. You have to prove that it's in self-defense, or you have to prove that it is absolutely necessary. So this is not based upon international law, but rather domestic law. This situation in the middle, this is very, how can I say, unstable. These are situations that Japan is not attacked, but may be resulting in the future a very big impact, particularly about situations such as the Taiwan Straits or perhaps in North Korean Peninsula. In these kinds of situations, the Japanese Self-Defense Force would have to or may want to, how can I say, support in logistics, transportation, as I said, under AXA. Now, even in these situations, the Japanese law says that there are certain limits. We cannot use force because under the Nicaraguan typology, it is not an armed attack. So we can't use force, but what can we use? In the case, they said we can use countermeasures with force, but that was later denied. So what they say is that we can use force, but in very strict situations. So, and this kind of transportation, it's a military operation, but it is not combat operation. So their argument is that it's not combat, so it's not the use of force. If we can take back the illegality of the illegal infringement, this would not collide with Article 9. So what would preclude this illegality? In Japanese, it's a big word, 違法性阻却自由. It means that if you have the consent of this territorial state, if it's in use of self-defense, or if you have a decision by the United States Security Council, this would enable Japanese self-defense force to commit this kind of operations. So it's no longer illegal. But since this is a legal vacuum in terms of international legal theory, we would have to employ in certain situations rights of collective self-defense, such as in situations that we are protecting assets of foreign forces, such as the United States, Australia, or other forces in these kinds of situations. When we have an armed attack, of course, we have the 3 new conditions, as mentioned earlier. These are also very strict. The question is, when does this situation come to this situation? And who decides what? The general rule is you have to have an approval from the Diet. But in imminent situations where it's an emergency, you can have the approval later, which can also be a point of conflict. Also, in gray zone situations, as I mentioned earlier, these are situations like, as I said, organized crime members, terrorists landing on islands of Japan and taking action. These are called gray zone situations. This was legitimized by a cabinet decision in 2015. As I said, if you wanted to go by the book beforehand, you would have to have 3 types of deliberations taking too much time. You can do this by telephone. So we can have technology invoked in this situation. So it swiftly makes this kinds of situations where you can have the Coast Guard and then the self-defense force during the same situation. These are also same approaches in terms of piracy in Japan, when you can't fight the pirates with grenade launchers with the equipment of Coast Guards, and you can't save nationals or vessels far away, because if you go far enough, you can't have an operation in the Indian Oceans by the Coast Guard. If you want to do this, you would have to have ships by the self-defense force doing these kinds of operations. These are what has been legitimized by the so-called LDP, or I'm sorry, legislation of 2015. Now, going further into our things. This is the argument of the government. If you look into situations like these, you can see that contrary to the image, the LPS is rather modest, should I say, to its image. because there are various limitations within the articles, it's not a full spec usage of these rights as it is displayed in media. Also, like situations like kaketsuke keigo, as I mentioned, going into PKO missions and using weapons in situations where a friendly is shot. This theoretically would be in situations like in South Sudan at the moment. So they said that we may have this situation in South Sudan mission where the self-defense force is already there. But they said that this framework is still not ready to be employed. So they said that we're not going to use this right until future times. So what they say is that the use of rights are still very limited, and also it would take time to talk about the operation of this framework and procedure to make this operational. And also in the meantime, we have tons and tons of, how can I say, suits prepared at the moment, contesting its constitutionality by lawyers and civilian groups. So we would have to probably wait for the decision of the Supreme Court of Japan. They have the final word in this kind of constitutional issues. And there are a lot of strategies that have to be dealt with. So though the news reports, they are very, how should I say, sensational in calling this war laws, if you look at this from the perspective of international law, you may say that it is not that radical. Also, but you can also say that there needs to be more to be discussed within the nationals. There needs to be more national debate on this issue. So this is my perspective, and these are more issues to be dealt with. Now the final word. Is Article 9 really obsolete or dead? From my perspective, no. There are still a lot of limitations based upon Article 9 in the framing built in. So it is very limited, but it is a bit stretched, even though, from my eyes. To do more, as Prime Minister Abe would say, you would have to change Article 9 and the Constitution. This situation is listed in Article 96 of the Japanese Constitution. You would have to have a draft that has support of 2/3 of both houses, and then you would have to have a national referendum. We had these articles, but we had no procedural law to realize this national referendum. So even though we wanted a national referendum, there was nothing we can do. This changed in the first Abe administration. They made a new legislation to enable to change or amend the Constitution. So there's a possibility to change the Constitution at the moment. But, and Prime Minister Abe has expressed his will to change the Constitution when he is in power, but I'm highly doubtful that this would ever happen. We need more deliberation within Japanese nationals. This is my analysis, and my main concern is that most of the material that I mentioned here, as I said first, is that it's not translated. I think there may be a lot of misinterpretations and a lot of people that are talking but not reading the statements or articles such themselves. So I think there's more deliberation to do within Japan, but also with foreign countries as well, with the international community to explain the government side. I'm not taking sides in this issue, but if we can do this, it says that my final word is that I think there's not going to be many changes in the future in terms of Japanese security. Thank you. This is the end of my speech. Thank you very much.